This
University of Miami
conference will now be recorded.
School of Law, he would tell you that I would never have been a real estate or property attorney or had any connection with it. In fact, he always remarked in class that he would call on me because he was confident that I would give him the wrong answer. So I'm happy to say that I think I've proved him wrong and have now enjoyed a career in real estate. At Broad & Cassell, my career started basically by assisting clients with the acquisition, development, financing, and leasing of real estate. There was a particular focus on retail shopping centers, large tracts of vacant land that needed development, and also residential projects and hospitals. I also worked on title commitments and negotiated and prepared purchase and sale agreements, commercial leases, development agreements, and other types of real estate agreements. My current practice, I serve as general counsel, outside general counsel to several firms or several companies in the area, and I do their real estate work. Last year alone, we did several warehouse purchases and sales in the millions of dollars that involved complex financing, SBA financing. I also do all the commercial leasing for these clients, in addition to helping with real estate matters transaction-wise for individual clients, and also with real estate litigation in Florida. And I'll tell you a little bit about that later when we get to some of the areas that I've noticed. So Bob, if we could move on to the next slide. So there's been a lot of rise in real estate litigation, and real estate is a great area to practice in because no matter how the economy does, there is always a different type of litigation. So if the economy's good, there's developer litigation, there's financing litigation. When the economy goes bad, we see a rise in foreclosure litigation and other sides. It's really a practice area that survives any type of market. It's just a varying type of litigation. But one of the reasons Florida specifically has seen a great rise in real estate litigation is due to our population growth. Some facts noted, Florida Trend Real Estate in September 2019 said we're seeing a population increase from foreign-born and northerners influencing real estate in South Florida. Broward, Dade, and Miami are getting about 94 new people a day moving to the county. Additionally, all studies have been showing that Florida's population has been growing consistently for the last 10 years at the expense of states like New York and my home state of Michigan. It is an estimate that after the 2020 census is concluded, Florida will be gaining 2 House of Representative seats and 2 electoral votes, making us the 3rd most populous state in the country and the 3rd most impact electorally. Could we go to the next slide? We're also seeing a rise in real estate litigation because there's simply an increase in real estate investors and real estate development in Florida, specifically South Florida and also the I-4 corridor. Recently, we've seen, as Jane Woodbridge of the Miami Herald noted in October 2019, the number of real estate investors and speculators buying up homes in South Florida has risen higher than most other metro regions in the United States. And again, Florida Insider magazine in July 2019 noted that the National Association of Industrial and Office Parks has once again ranked Florida in the top 5 states for all commercial real estate development. In fact, just a few days ago on February 12th, 2020, there was a massive real estate conference and development conference that took place down here in South Florida. All of the major players in the real estate investment and development game were present, with actual panels including people like Gil Deser of Deser Development, Louis Birdman, Edgardo de Fortuna of Fortune International Group, Shahab Karamli from Carr Properties, Royal Palm Companies, Eric Forden of the Related Group. All of these major companies, major developers, and also the people that are financing their projects were at this conference. And the takeaway from this conference was clear. Development in Florida is booming, specifically in South Florida, and specifically South Florida, Miami-Dade County, but also the I-4 corridor and that area between Tampa and Orlando has many new and exciting projects that are going to be on the rise. And with the rise of those projects, we'll also see litigation linked to those and opportunities for mediations related to those. Additionally, Jacksonville has a significant rise in development and also foreclosures, as I'll talk about. But Florida specifically is a great opportunity for transactions for real estate, but inherently that comes with litigation. If you could have the next slide for me. I know the graphic is a little hard to see, but it's not the graphic that's important. In this, we see that in Florida specifically, while foreclosures are down on a whole nationwide from when the market crashed, starting last summer, Florida actually saw an uptick in new foreclosure filings, specifically in areas such as Deltona, Daytona Beach, Florida. We saw an increase. Jacksonville saw an increase with 1 in every 958 housing units being in foreclosure. 21 states and the District of Columbia posted increases starting in July of 2019. Is this the start of a new foreclosure crisis? If I could tell you that, I probably would be making millions of dollars and finding great opportunities. I don't necessarily think it's a new rise in a massive foreclosure trend. However, it's interesting to note the trend is an uptick. So for example, RealtyTrack, which is an independent outsourcing service that tracks foreclosures, is still showing that Florida is slightly up in their new foreclosure filings in 2019 and into 2020. Florida foreclosures that are currently set for auction are actually up 14.3% from last year. And bank-owned properties, the amount of properties in the state of Florida that are now currently finished their foreclosures and the bank is holding them, is up 6.1% from last year. So there's some interesting things going on in the foreclosure side with auctions, bank-owned property that has a lot of opportunities, not only for foreclosure litigation, mediations related to that, but potential litigation stemming from when the bank gives it up to new people around assessments and other matters that may come up. If I could go to the next slide. Other reasons we're seeing an uptick in litigation is actually the rise of coverage about litigation nationwide and worldwide even. Some of the most prominent resources, at least ones that I enjoy and ones that have significant followers, are Above the Law, Law 360, The Lawyerist, Legal Reader, Bloomberg, and that's not a political endorsement. It just is a great source of stuff related to real estate litigation, and Rocket Lawyer. These are blogs and news agencies that cover novel legal issues and in states that are not Florida and also worldwide. And by reading these, cases that are stemming in those states and other countries are gaining traction in other areas like Florida. So for example, I was recently reading a trend in Texas from one of these sources that said there has been a rise in condo association cases and condo negligence cases stemming from condo associations not maintaining proper levels of humidity in common areas of the property, which has led to mold growth and other property damage issues. I imagine South Florida specifically, and all Florida really, with the humidity concerns we have here, that coverage of litigation like that that's been leading to successful results and successful mediations stemming from claims like that may result in a trend of increases of novel legal issues like that. If we could go to the next slide. In speaking with other members of the real estate legal community down here in South Florida, being in different courthouses down here, Miami-Dade, Broward, and also federal litigation, we are seeing a rise of specific types of litigation. So for example, we're still seeing a lot of first-party insurance claims due to storm damage and flooding. Just the other day, I was in the Miami-Dade courthouse, and there was at least 10 cases on a regular motion calendar docket stemming from Hurricane Irma claims and actually other storm damage claims, even regular thunderstorms that have resulted in flooding issues. I can tell you I've also experienced a rise in cases stemming from flooding specifically. The city of Hallandale and Hollywood have specifically had some flooding issues relating to their storm sewer drainage systems that have led to homes being flooded, not even in major tropical storms, tropical depressions, or hurricanes, but actually thunderstorms that just have a great deal of rainfall. So we've seen an uptick in that. There may be other areas of the state where that's also occurring, but personal knowledge of mine, I know specifically the city of Hallandale and the city of Hollywood and Broward counties. I'm also seeing a rise of buyers bringing actions against sellers for misrepresentations in purchase and sale contracts and also the closing affidavits. And this is very important and why we always recommend that buyers and sellers always seek to retain an attorney to assist them in the transaction, because in order for a transaction, specifically one that will be secured by a mortgage, to have title insurance issued, certain representations and warranties are required to be made by the seller. Oftentimes, sellers who are unrepresented are showing up to closings, signing these representations that may not be fully accurate, but with proper legal counsel, they could have helped them narrow that language to still satisfy title concerns, but not make a statement that would be false if actually reviewed closely. And this involves cases about defects in the home, specifically the FAR-BAR contract. If any of you are familiar with it, the FAR-BAR contract is the standard form for most residential property purchases in Florida that have already been constructed, not truthfully for pre-construction cases. But this form has an area, section 20, that has additional terms. As someone who assists buyers and sellers, I regularly alter the terms of the FAR-BAR by amending it in that section 20 to add different terms and representations depending on which side I represent, and also sometimes even add my own addendum. If people aren't watching these closely, these addendums can have grave implications for them and the representations they're making that can result in litigation. So it's important to read those closely and monitor those, because we are seeing a rise of litigation in that area. We're also seeing a rise of loss assessment claims. And loss assessment claims are claims usually brought by condo owners, homeowners association, or other association members, stemming from assessments made by their condo boards, HOA boards, property owners association boards, usually linked to storm damage deductibles or things that weren't necessarily covered under an insurance policy. Some of these policies the insurance companies are paying out. Others are fighting that litigation and saying that they don't have an obligation to cover the loss assessments. These loss assessment policies can range from small amounts of 1,000, which cases are done in small claims court, to ones that cover large amounts of assessments from a condo homeowners association, property owners association. The largest one I have personally seen was a loss assessment policy that provided coverage of a loss assessment for $50,000, and I'm currently involved in litigation concerning those today. I've also seen a rise of complex cases involving equitable liens. With some of these, in the nature of case law that has come out concerning foreclosures, these complex foreclosures that involve standing issues and other matters have led to amended complaints that are also alleging an equitable lien on the property. And I know of at least 2 in million-dollar properties that have had successful claims for equitable liens here in South Florida when they had difficulty proving standing through the actual notes. It'll be interesting to watch that litigation develop in the appellate courts moving forward, and I'll tell you all some resources about that later on in the presentation. Other things we've seen are unpaid brokerage commissions. This is especially large in South Florida, where we're having sales associates not getting paid by their broker, and in some cases very large amounts of money, and there's disputes over who was the procuring cause of the deal. And myself and several other law firms that I speak to regularly on real estate issues have been approached by numerous brokers or sales associates for the prosecution or defense of the cases. With the rise of storm claims, we'll inherently see a lot of loss assessment claims and other first-party claims, and also third-party claims when it's the result of flooding in a condo from an upstairs unit. Those cases won't go away, but right now we're seeing a rise of it. And again, I'd be remiss to say we are seeing a rise of foreclosures in some parts of the state, but not all. We could go on to the next slide. Especially as mediators, but also just anyone practicing in the areas of real estate law, specifically when it comes to litigation, really needs to focus on certain matters that they need to consider at the outset of the case or in a mediation when resolving that case. For example, one of the things I see overlooked all the time at mediations are documentary stamp tax and intangible tax. A mediation may result in a creative resolution of a case where one party is granting a private mortgage over a property or deeding over a property to another party for a certain amount of money, yet the mediation agreement is not referencing who is paying doc stamps or intangible tax, and the mortgage documents that are drafted in connection with that aren't referencing that either, and we're seeing greater disputes from a mediated settlement about who's responsible for those fees. So those are things that you definitely want to consider when mediating a real estate case as a checkbox of, okay, is this a type of settlement that will trigger a documentary stamp tax payment or an intangible tax payment? And let's make sure we cover who is responsible for that payment while we're drafting this settlement. You also want to make sure that we're checking for open permits on properties and other lien issues, mortgages, private liens from construction companies for work that's been performed, or other encumbrances, whether it's by the city for violations, anything of that nature. Because at a mediation where you can be creative and settle a case by transferring property, quit claiming rights, granting private mortgages, it's good to have this base of knowledge, because you never want someone to reach a deal only to find that the property they got, which they thought was a great deal at mediation, had significant encumbrances, liens, other issues that have really lowered or diminished the value of what they thought they got or settled at a mediation. One of the biggest things I always want to make sure people do is make sure that you know who is required to approve or at least sign off on any type of settlement at a mediation. So for example, there might be homeowners association, property owners association, or a condo board approval for a specific settlement. In cases of first party insurance, you want to make sure that the public adjuster has signed off or at least has been clear about what percentage they would get from that. Additionally, a lot of property owners have come to me after mediations that I did not represent them in, saying my mortgage company now will not let me or will not sign off on the check I granted because they want me to use specific people to do it. They want to hold the money and release it on a construction schedule basis for the repairs. So those are all things you want to consider, especially in storm damage and other damage cases for first party, because it's always difficult to see a homeowner or a unit owner know they got a settlement only for their mortgage company to say, well, I'm going to hold on to that and we're going to do it and you need to use these people. It's good that everyone goes into their settlement knowing what will be expected and how that money will be paid out. Additionally, the existence of insurance and what insurance is at issue in a litigation is especially important to know for a mediation and reaching a settlement. In general terms, if it's a first party insurance case, that's easy. However, if it's a litigation stemming from negligence, is it a covered event? Has there been a denial by the third party's insurance? Is this a title insurance claim that you should consider, where the person actually should be making a claim on their own title insurance because it affects their title to the property? Lastly, especially in South Florida where fraud is rampant and we have a lot of deed fraud in South Florida and Florida in general, you want to make sure that the proper party is there at mediation or has the proper authority to settle via certified documentation, powers of attorney, confirmation of trust documents of who can do it. There's a lot of properties in Florida held by trust. signed by people with attorney or powers of attorney. You want to make sure that all of those comply with the law and are documents you can rely on as a mediator to ensure that the settlement that's being reached is a proper settlement by someone with authority. I specifically had a consultation recently where there was a mediation. I was not the attorney of record in that case, and there was instances of properties, numerous properties changing hands, private mortgages being given, and there was a concern that some of those properties that a person thought they were receiving wasn't actually deeded by the person who had the authority. Additionally, there had been no consideration for documentary stamp tax or intangible taxes, and based on the number of properties at issue and the value of the mortgages at issue, this was a significant financial oversight in the tens of thousands of dollars. So it's important to really focus on these key issues. And again, these aren't all the issues that need to be focused on while doing a mediation, but these are some main key facts that definitely need to be considered and to ask the parties about so they can think about that at their mediation. Next slide, please. Mediation and real estate cases, they go hand in hand. These are prime cases to be settled at mediation. And I know many of you who do mediation in this group know these bullet points well, but I want to run through them because it's always good to have a reminder about these. Is real estate cases are great for mediation because the cost involved to mediate is usually de minimis compared to the amount or value at issue for a specific real estate case. A lot of times, especially if it's a probate case that involves real estate, you are having to deal with emotional attachment and nostalgia issues that are best suited for skilled mediators like yourself to resolve this issue, where the courts may not always be in tune to dealing with those emotional attachments. Skilled mediators like yourselves can really focus on that and help parties reach a resolution in spite or considering those emotional attachments. Obviously, mediation provides certainty and usually a quick resolution to cases where it's important because unlike some litigations, there aren't a lot of cost involved necessarily for personal injury or other things. Real property, when there's a dispute about ownership or other matters of real property, there are daily carrying costs for these properties. Tax bills, insurance bills, electricity, and other utilities. So the quicker a resolution can be met in a real estate deal, the more money that is saved by the parties on a whole. Again, mediation obviously typically less stressful, as you all know, but this is especially important for real estate mediations, is that it can provide personal and creative results that legal proceedings simply may not do. A lot of times we're in court, we're suing over money, some matters of equity, but at a mediation, you can come up and structure a creative deal that allows someone to stay in a property for an extra period of time, do private mortgages, quit claim different deeds and properties to each other, and really create something creative that works that sometimes the rigidity of the legal system doesn't provide for that creative result for people. Next slide, please. I do a broad range of litigation: personal injury, family law, real estate litigation, general business litigation. And the one thing, or the one type of case that I always make sure I do an extremely detailed mediation statement is in real estate cases. I really think it is the cases, or these are the types of cases that you all are, as mediators, should strongly encourage the parties involved to provide as detailed of a mediation statement as possible. And I've listed some areas, we'll go over them. These areas are really important for you all as mediators to know prior to going into the mediation, but it also allows the parties to focus on these issues going in, so there can be less time spent answering these questions at the mediation. Doing detailed mediation statements with these factors allows the parties to both go in early, think about the issues, and really get to the meat and bones of it, rather than having to look and find these things at the mediation for all the mediators and the parties. Things I always make sure I personally include when I'm preparing a mediation statement for mediators, and I strongly recommend that you all request when doing private mediations on a real estate matter: a description of the property at issue. And that includes not only the address, the owner information, how that owner has the authority to sign, because it may be a trust or some LLC. You want to make sure that you know how the owner has the authority to sign off on any settlement for that. The parcel ID, it's just good to have clear information about what property are we talking about. The nature of the dispute in the parties: is it a buyer and seller, landlord tenant, insured insurer, unit owner association? The third is one that is often overlooked, and it can have financial implication, is: are there any mortgages, liens, or other encumbrances? And if there are, I think those should be provided, copies of those, to the mediator in advance with the relevant sections highlighted. That way we're not combing through these documents, which are often very voluminous in nature, and we know the specific provisions at issue. And the reason it's important specifically on mortgages is because if your creative solution at a mediation is a quit claiming of property, or even a sale of property that's encumbered by a mortgage, and that one party is going to take a property subject to that mortgage, you've now triggered an instance where documentary stamp taxes have to be paid on the remaining balance of the mortgage. If that issue is overlooked at mediation, there now could be a several $1,000 financial matter that wasn't addressed at the mediation. If it's a matter that involves insurance, that's obviously easy if it's a first party case, a loss assessment case. But if it's an interesting, complex legal matter, it's good for the insurer, or it's good for the mediator and the parties to know: are there policies at issue? If so, what sections? And have those sections marked for your benefit as a mediator, but also theirs to be thinking about it. It's good to have pictures when there's storm damage, flood cases. That way those pictures can be given back and forth at mediation, so the parties know what they're talking about. And we've hit on it before: confirmation of any approval. Is this settlement we're going to need require anyone to do HOA, POA, condo board approval, public adjuster approval, mortgagee approval? And I always like to provide the copy of the most recent deed for the properties at issue. Next slide, please. I'm going to go over some of the helpful resources that I use in preparing for my litigation cases, for reviewing my cases, and also just to stay abreast of recent developments in real estate law in general. One of my favorite resources is the real property, probate, and trust law section of the Florida Bar. I know the graphics are a little hard to see on there, but it's not the graphics inherently that are there. This section of the Florida Bar has a free section on new decisions that come out, new appellate decisions, and they post it right on their website, and that's what that graphic on the right is. And these are updated very, very often. The cases that are listed on that graphic, while hard to see, are cases that came out in appellate courts in late January of this year. And what's great is it's written from someone that is a member of the real property, probate, and trust law section of the bar. It not only provides an analysis of the case with: this is the facts, this was the holding, but it also does a critical analysis that says: what are the implications of this case moving forward? How could this case be used in future litigation? I monitor this site regularly, read their updates. It is a free resource that provides a vast amount of wealth and knowledge for you to help build your real estate practice, and also assist you in understanding complex real estate issues at a mediation. Additionally, this section has CLEs, articles and editorials, and also they host great conferences on real estate as a whole, broad range, but also specifically when you narrow it down, they do condo law, construction law, all the very niche areas of real estate law in general. Next slide, please. The Florida Bar also has recently updated their practice resource center and branded it Legal Fuel. This website, I recommend all practitioners, all mediators, take a look at this site. They've done a really great job enhancing and making a user-friendly interface. This site has free CLEs, podcast, discussion boards where you can bring up topics, specifically real estate matters. They've got form documents you can use. I think every practitioner and mediator would benefit from reviewing this site, seeing the resources they have, especially if there's an area like real estate that you want to stay fresh on, new topics, new discussions going on in Florida specifically. Next slide, please. I'd be remiss if I didn't note the American Bar Association. Their real property trust and estate law section is excellent. It is updated every week with new information. They host free CLEs for members. They also have a real estate news and information. And on this site, they talk about trends in the law nationwide. They go about international real estate issues. They focus on the interplay between estate cases and litigation and real estate. And it's really, they can get very broad range in general, but they've had articles and focus areas specifically on Florida and other states where they really get practitioners from around the country to provide some great resources for anyone looking to get more involved in real estate in general. Next slide, please. Some of the helpful resources for mediators and practitioners to use that I think are often overlooked and maybe helpful at a mediation if someone hasn't done their homework are websites like Miami-Dade counties. They have their taxes on the website. You can look to see, does a property at issue in your real estate litigation have any tax certificate issues? Is there a tax deed sale coming up? Miami-Dade's is actually a very good website. I can't vouch for all county websites, but I highly recommend that when you're mediating cases, take a look. That way you can see, is the property and the county that that property is located in, does it have a tax website, and is that tax website showing any tax issues that we need to be concerned about? For example, tax certificates, outstanding tax certificates are a primary area you want to look for, because that means there were unpaid taxes that may need to be addressed as part of the mediation that you're a part of. This may be an issue that wasn't thought about or looked at by the parties, but you as a mediator, just by simply typing in the address or the ownership to the property, can go, you know, I looked, I see there may be some tax certificates outstanding. Is that an area we should address at today's mediation? Next slide, please. There's also many helpful resources in Florida counties, specifically the larger counties and larger cities that have permit searches. So the one on this slide is from the city of Miami Beach. You can type in a zip code and find any outstanding permits, whether they've been opened, whether they've been closed, to stay abreast to any issues that may need to be addressed. So in the same way that outstanding tax certificates, unpaid taxes could be an issue at mediation, you may also have an open permit issue that you as a mediator could do a quick check on, or ask the parties to do a quick check on, to ensure that there's no permit issues that you all would want to address at that mediation. Even if it's not the main focus of that litigation, it's helpful to put a nice bow on the case, make sure all those issues are done. That way there's no loose ends after a settlement. Next slide, please. Sometimes at mediations, we're doing a transfer of property, and that transfer is going to be more than a quick claim. It's going to be an actual agreement to purchase and actually insure that property with title insurance. One of the issues you may want to address in a mediation is, what is the cost of that title insurance? Who's going to be responsible for that? Because this is a several $1,000s matter that should be addressed. Typically in Florida transactions, if it's just a normal purchase and sale, the contract will say, however, if you do have a complex real estate deal, you want to make sure that you're addressing this. online. This is one example of a Florida title insurance calculator that you can use to get an estimate of what those fees would be, so the parties know and can discuss those topics and who will be responsible for those fees at the mediation. There are other ones that you can find online. This is just an example of one that I've used, but these numbers and the values are promulgated by the Florida Department of Insurance in the Florida Administrative Code. So you could do the calculations yourself if you know the formula, but I find these online calculators are helpful, at least in getting a very close estimate of what those fees might be. Next slide, please. We talked a lot about doc stamps and tangible tax. Recording fees are also another thing that you need to focus on at your mediation. Is your real estate settlement that you're doing going to have documents that are being recorded? Who's responsible for those fees, the doc stamp fees, the intangible tax fees? Broward County, Miami-Dade County, Orange County, and other counties in Florida often have online resources to help you calculate or at least estimate those fees. That way you can discuss those values at your mediation to make sure, again, we're not leaving a loose end. We're covering all of the potential expenses that may rise out of a settlement that you could reach. These are easy to find online. And again, these aren't fees that are just a couple bucks. Sometimes, for example, in this estimate, I know it's hard to see on that slide, I did a $1.55 million home purchase, and we're looking at doc stamps on the deed over $10,000. So we don't want that kind of oversight when there are such easy and helpful resources online that you can use to help calculate these fees. And again, it's easy to overlook them when we're doing big picture about who should be the owner of this property or how are we going to split this property. You got to make sure you get down to the nitty gritty, get the details, so that way we're not overlooking a significant amount of money. Next slide, please. I just want to do a special thanks to the Academy, the Florida Academy of Professional Mediators. It's the oldest professional mediation organization in Florida. They host great events. As Bob was saying, this monthly CLE program that you all are trying to get going off the ground and keep going is a great idea. You all have done excellent work, great events, and I'm glad to now be a member of the program or of the Florida Academy of Professional Mediators and look forward to great events moving forward. So thanks to everyone involved. Thank you all for showing up, and thank you to the Academy for hosting events like this.
Thanks,
Next
Daniel.
slide.
Thank you so much. I really do appreciate it. Let's see, we have any questions?
Yeah, I know that it's President's Day, so if you want to go to the previous slide real quick, Bob.
Which one?
It's my contact information. Perfect.
Okay.
I know it's President's Day. I know this is an hour presentation. I'll take some questions if anyone wants right now, but here's my contact information. If you want to bounce a specific idea, a complex idea, discuss real estate, please feel free to shoot me an email or contact me. I'd be happy to discuss it with you. Any potential case you're working on, anything that you might want to discuss in the real estate realm, I'm happy to do.
If you do have a question, you can type it into the chat window. If not, again, I just wanted to reinforce that these monthly webinars are a wonderful benefit for the Florida Academy of Professional Mediators. We keep our dues very reasonable. As you know, it's $75 for annually, and if you're a diplomate, it's $100. There's a lot of benefits. You get an enhanced listing, which is another way that you can be found if somebody is looking for a mediator in your area. I'm happy as the webmaster to assist you. You know, there's a helpline that I get back to everyone within 24 hours. Rand is mentioning, are we going to get certificates for attending in case we are audited? I'm not the DRC, but with the way the president has explained it to me, this is self-reporting. When you register for these webinars online, okay, they are in your account. If they're not, I can produce an actual receipt for you. But as far as an actual number, the way it was explained it to me, and I can get more clarification, is that it is self-reporting. So I'll double check again with the president, but this is the way she explained it to me. Paul, I don't have a CLE number. Again, this keeps coming up in conversation. Again, I'm not a mediator, I'm the webmaster. I'm going to get official ruling from the president and who talks to the dispute resolution center in Tallahassee to answer those questions. Okay. So Daniel, again, thank you so much. Yes, this is considered a live course. Absolutely. Okay. It is 100% live. Oh, we are going to put the recording online. It's going to be free to anybody that has attended. It will show a $10 charge, but I'll give you a private viewing place to get this. And you can just contact me. There's two ways you can contact me. It's either through my email, which is B as in Bob, Levin. I'm going to do that phonetically. L as in Larry, E as in Edward, V as in Victor, I as in India, N as in Nancy, the number 26 at Gmail, or you can go on the tfapm.org website, go to the live attendant, just type in your message. If I'm not there, I will get back to you. So I want to thank everybody again. Daniel, again, it's wonderful. And we'll talk to you guys next month. Thank you.
No, thanks everyone for joining. I really appreciate it. It was an honor to present.
Thank you. Appreciate it.
Bye-bye now.